I like it when young people try to challenge the status quo. Now, there is a young guy, your friend, Seth Do, our lawyer. Now, watro a 7-paged article and a 7-paged document, okay, just for the want of a better word. We're explaining the reason why a Supreme Court ruling omo edebae against Abambagbé no wrong. And so I just want us to go into it and then see say the young, and listen, I know a lot of people come and say oh you're young, or you say in fact old lawyers are omunina neutral crash as some. In fact, people we know who are even close to sa MPP are buying MPP, some MPP figures cry use no. I mean in court cry no. Ebi mo ababonti a wo ka said that be Supreme Court decision a wo take it sebe na ababia enim. And so let's read the young guys, the young minds in Ghana, young lawyers in Ghana, what they are also saying about this. Now, say stay of execution of declaration of vacancy by the Speaker, why the Supreme Court got it wrong, by Sedo Esquire. Also, the Supreme Court of Ghana had an ex parte application for stay of proceedings application on October 18, 2024, and stayed the ruling of Speaker of Parliament Abambagbé in a matter of the vacation of some 4 seats. The matter was brought ex parte by the applicant Alexander Afenyomakin, the plaintiff in the substantive suit, before the Supreme Court filed on 15th October 2024, titled Alexander Afenyomakin versus 1 Speaker of Parliament, 2 Attorney General, number J1/01/2025. Now, see, the applicant claimed he came ex parte because of the urgency of the matter, and upon the conjoint reading of Article 29(5) and Order 1933 of C147 of High Court Civil Procedure rules, and where the subject of the application is likely to cause irreparable damage, a stay of execution must be granted. The grounds for the application were that A, ex parte because of the likely mischief being a halt to the business of Parliament, especially committees chaired by the current majority members. B, likelihood of the current minority members doing everything in their power to halt business of government in this dying minute of the period of 2024 elections. C, a delay of government appropriation which could require the approval of Parliament. D, the ruling amounts to a denial of the constitutional rights of these 4 constituencies to be lawfully represented in Parliament. The Supreme Court heard and granted the application based on those grounds, thereby directing Parliament to recognize and allow the affected members of Parliament herein named to duly represent their constituents and conduct the full scope of the duties of their offices as members of Parliament pending the determination of this suit. The decision by the Apex Court effectively suspends the implementation of the Speaker's ruling on September 17, 2024, pending further legal review and final determination. This essay seeks to criticize the ruling of the Supreme Court as outrightly flawed based on 2 grounds. 1, the Supreme Court did not have jurisdiction to entertain the substantive suit and lacked jurisdiction to grant the current order directing the stay of execution of the ruling of the Speaker. 2, the Supreme Court was outrightly flawed in holding that the matter was a matter of urgency because it was a human rights matter, as the members of Parliament were not granted the right to be heard and their constituents could lose representation in Parliament. Now, Muamunim say, me be reading the sana here. This is the time I was a metrasie. Now, the young guy no eshasie case ni na de eshasie say Afenyomakin no di mmirika court. The Afenyomakin di mmirika court no okosiki for ade bia ye friend ex parte. Now, ex parte application is very simple. Say me de wo court a e wo say onso oba beka wasem na yetie. Normally in sanity. Say me de wo court a e wo say onso ode wo lawyer ba na oba beka wasem. Now so be at the ex parte court. Or court akwa court say mesrew asem we a ekoso no e asem bi a ehu hia enti nipa kro no eni kwan se ogina ha na otie nsɛm no eni kwan sɛ wɔba na ɔno ba bɛka n'asɛm ba nipa koro na de a wɔyɛ no ɛho hia sɛ when take action sisi a ebia ɛbɛbɔ ɔman no ɛne ne ɛfɛ no ex party nti ex party a wɔn de call court a wɔn kɔ akɔgye no afɛnyuma kende call court no nsɛm a ɔkɔ court ɔkɔkɔ kan no na nsɛm a ɔde mirika kɔ ɛsɛ deɛ nti a wɔn feel sɛ deɛ ɛkɔ so na ɛho hia na eni kwan sɛ yɛfrɛ Abambagben ene ne lawyer say wo embra mbeka wo mo asem na ono pene de ne yentie no asem a wo kan say one ex party because NDC for ashada ba be take over parliament a omo play mischief wo mo pese wo mo say aban adwuma it is ansem a afenwuma kende koy no reason say all the America e call Supreme Court no say Supreme Court ndi asem ne ntem because omo ndi ne ntem a NDC for in the name of a majority no omo begu aban no. 2 senior yeka no doing everything possible in our power to halt business government in the dying minute say MPP aban Ekufuado aka ne be 2 months pena we free so nti NDC for ye de omo be ye bia no mbe say aban no. 3 I say a delay of government appropriation which could require the approval of parliament. D. The ruling amounts to denial. Now, I have say, and also esansu here, I watch say, sa 4 constituencies here, Abambagben declare vacant no. Sa parliamentarians ye tia wa mumra eso. Na keni kwanza Abambagben declare mu vacant. Because Ghana mra say, also be a enya representative. It is ye ni e declare mu vacant dia na trese pese trese nkrofo no mu ni MPs nti eno nso ya asem a ode kokodai ho. Now young guy ya asem a waka no say the nti o feel say Supreme Court ruling na wode baaye no nyansa enim ana enye se nyansa enim sa but eye wrong bin kan sa the nti o feel say Supreme Court ruling they by wrong they say one in the first case no we share the nature of the case afenwuma kende call Supreme Court na enye Supreme Court impo na nke o set na sa case ne so ye wo cases bia you the call magistrate court and magistrate you the cases be you the call high court your cases be you the call appeals court and your cases be you the go Supreme Court. It is the nature of that case and your human rights court kra nature of case and your Supreme Court and anke was say etina asem so nti no crampo no wrong. Lawyers will tell you say procedure is equally important as the case. Lawyers be Rebecca's asem natural. Say procedure equally important. Into a lot of cases call Supreme Court no, and a lot of cases call courts no. And yet even the case no merits of the case but senior would the case no so yeah then bano and also it speaks a lot. Okay, no problem. Into no and a perfect example they say police for ebetumi akwa akɔchi obi no msin pa ko ne kun bi but ebia senia wo mokonya evidence and no msin pa ko na bokro no but senia mokonya evidence in America it happens a lot senia mo ye nya evidence no mo amfambra kwan so nya evidence it to me bo asem ne ye den egu. Okay, into your say in the first place Supreme Court no kra no need jurisdiction so better na sa case so the matter sa case no the nature of that case no constitution ne say enye Supreme Court impo ne o say di. It is the Supreme Court the ruling about ya omo wrong. Second, I say Supreme Court no senior ye can omo wrong. Say omo hold the matter as a matter of urgency. Say Supreme Court for ye de mirika ba say asem no we de as ahunhihi asem say wanya ne ntemu a oman ne bebo a Supreme Court na tena case ne so ntentem sa no asem we nya asem bia na nka ebetumi ahwe ma oman no ayeden abo nti sa enu hunti a ye de ma sa ruling ne kra na wrong. Abranche ne nsem no. Also jurisdiction. The entire worker says Supreme Court in any consulting case needs to know betrim. The Constitution expressly states under Article 99(1) that it is the High Court that is vested with jurisdiction to hear and determine any question on whether a person has been validly elected as a member of Parliament or the seat of a member has become vacant. Into Otremu say Ghana Article 99(1) atro wo say the only quarter say parliamentarian enya asem say e was say yi ne konwa efiri ho, the only court e was say otena asem ne so no e high court enye supreme court. It in the first place no say supreme court amasa a decision we ne kra na wrong. Because a person aggrieved by the determination of the high court and that this article may appeal to the court of appeal. In the high court never ruling ni we now hena sanso we near no akwa appeals court. Therefore, any matter that dealt with the membership of parliament and vacancy of parliament is vested in the high court as the court of original jurisdiction with final appeal to the Supreme Court. This meant that the Supreme Court bore no jurisdiction pertaining to any matter concerning the membership or vacancy of parliament unless a matter of interpretation arose in the High Court which will lead to a stay of proceedings in accordance with Article 192 to refer the matter to the Supreme Court for interpretation. So Tremu say, a High Court, any idea asem no. Or say call High Court, maybe a nipa krono fili say yendi na asem yo de beko appeals court. Or call appeals court na still wo hu ne say yendi na asem ni ya e hono beko Supreme Court. Na asem we kra no, any kwan say anka immediately no Supreme Court ebem. Na nka was say Supreme Court bemu a ebi a case na ekoso wo High Court no na ebi a yese insem bia ba ye ntia ase na no ya kasa okay Supreme Court ebe ma ye ntrase nti ne yenko Supreme Court yenko je ye de ntrase mbra ne yembe continue case no e wo High Court nti se ube ha Central Coffee omonso case no, that is exactly what happened. Omoko High Court omo di case no wo High Court obonsomo aka say enyama bi epiem wo High Court o yente ase obonsomo aka Supreme Court na Supreme Court abo omo back say ye de say ne yete ase ntem nko back to the High Court. Into what say parliament and a parliamentary case biano, that is how it is supposed to be done. Yempe mirika empe intem emfa nko Supreme Court. Into Supreme Court edi mirika kwa ko di asem di we yaba no. Why you wrong? Young guy. And you see, the reason why I'm reading this, Nikrane say, I have heard the old lawyers say the same thing. Mahama Yariga did a perfect interview on Joy News where he explained these things. Atiasiye, Eman Crawford atiasiye. Now, apparently anyway, you know, and on Sanso, Eman also a lawyer. Lawyers the omuya or mama precedents. To we you know, and on Sanso ma other precedents of cases bia and also a course also. It was in Yeboah versus J.H. Mensah, 1998 to 1999, SCGLR 492. The plaintiff brought an action in the Supreme Court invoking the court's enforcement jurisdiction under Articles 2 and 130I of the Constitution. 1992 for a declaration inter alia that under Article 94IB, the defendant was not qualified to be a member of Parliament. The defendant objected to the propriety of the action on the ground that the plaintiff's action was, in substance and reality, an election petition determinable only by the High Court under Article 99IA of the Constitution. The Supreme Court upheld the objection, holding that the plaintiff could not ignore the provisions of Article 99IA of the Constitution, which had provided a specific remedy at the High Court for determining challenges to the validity of a person's election to Parliament. To trim, say around 1998-1999, case be basa, no so sa ye say ni pekrubi eni kwan say ye man ye MP in sensem sa na asem ne kokopie mu Supreme Court na Supreme Court ka say dabi Ghana mra no etre say MP nsemba ne ye pese ni pakon na etu ni fi akonya so a enye Supreme Court na wo say tena so eye High Court into Supreme Court na san so bo case no e call High Court. Also the same Article 99(1)(a) provided the similar remedy to the High Court in any matter concerning the vacancy of Parliament. In Yeboah versus J.H. Mensah, Supra, Charles Heffron Benjamin, JSC, added his wit to the principle as follows. When a remedy is given by the Constitution and a forum is given by either the Constitution itself or statute for ventilating that grievance, then it is to that forum that the plaintiff may present his petition. It was in that same case, no. Judge Bakwa was in a case ne so I friend Charles Heffron Benjamin. Justice of the Supreme Court. Judge no in some way what kind was our case ne class say. Constitution ne say assembly ba na asem no eye eha ene edi asem na eno na wo se wudi so. It is a constitution na aka pefe say ebia krononsem no ebia yedi no high court ana yedi no magistrate ana yedi no ha constitution ne tre say financial irregularity yes say financial irregularities yedi no in the financial courts ho na wo se okokodi no men courts bi abium inti judge ane ye frɛ no he from Benjamin Charles he from Benjamin o si so can say sa ena etie inti young guy lawyer or training na adwen we yenye say atemdidie or kan nsem no man examples bobo the reason say until feel say Supreme Court no indicates ni ye. Also this was affirmed in the case of Real Parliamentary Affairs Zakaria versus Nyimakan 2003 to 2004 SCGLR, where Achuguba JSC made it clear that when an issue of interpretation had arisen concerning the eligibility of a person to contest for the parliamentary seat, the trial judge should have stayed proceedings and referred that issue to the Supreme Court under Article 132 of the Constitution for the determination by way of interpretation, even if the provisions seemed clear and unambiguous, such that of Article 99 1A. And then he went further to give another several examples. I was say Zenato Rawlings Munina in 2016, the court affirmed that the High Court had original jurisdiction in all matters concerning the determination of membership in Parliament. Into Zenato Rawlings Munina no 2016, say the Sadia ne no. Emma High Court near the court Supreme Court say Parliament in same dia a High Court any den de court. And so he has given enough examples that a say the case I will make, that is it. Into or conclude on the first reason. One say one or two reasons in here I will say Supreme Court wrong. First, or say the jurisdiction. Supreme Court didn't have jurisdiction. And a second, human rights issue, into or conclude on the jurisdiction. Or say the Supreme Court is vested with jurisdiction in the interpretation and enforcement of the provisions of provisions of the 1992 Constitution per the applications of Article 2.1 and 131. However, this jurisdiction is subject to the provisions of the Constitution under Article 33.1, where the matter concerns the enforcement of the human rights provisions of the Constitution by a party personally aggrieved. The High Court is vested with original jurisdiction under Article 99.2. The High Court is also vested with original jurisdiction in determining membership of Parliament and vacancy of Parliament. This means that any substantive matter dealing with the vacancy of Parliament had to be referred to the High Court first. If a party to the suit believed that a provision of the Constitution needed interpretation, the party should apply to the High Court for stay of prosecution for the matter of interpretation to be referred to the Supreme Court for interpretation. We're making the case. The first one. Second one, see human rights. In the Supreme Court's ruling on the ex parte application for stay of execution of the ruling declaring for parliamentarian seat vacant, the Supreme Court stated that it appreciated the urgency and special circumstances presented to support the filing of this application. The urgency and special circumstances lie in the effect of the impunged ruling, which included 1. Depriving the 4 constituencies that said MPs represent, namely I, Honorable Andrew Esiama, MP for Fomena constituency in the Ashanti region, and current second Deputy Speaker. I, Honorable Cynthia Morrison, current MP for Agona in the Central region. I, Honorable Kojo Asante, MP for Suhum in the Eastern region. IV, Peter Yakwachi Aka, MP for Amenfi Central in the Western region of representation. The said 4 constituencies in Ashanti, Eastern, Western, and Central regions have been deprived of their basic democratic and constitutional right of representation in Parliament until the next Parliament by the said ruling. The court also emphasized that aggrieved parliamentarians were not granted the right to be heard. I say the right to be heard is a human right and pertains to one aspect of natural justice, odi alteram partem. The right to representation is also a constitutional right. However, it is essential to note that every human right is not a broad blanket but subject to restrictions provided in the Constitution in the public interest and also the respect of the rights of others. Into a trim say, Senya, Omobaya Omeka say, oh, the reason in tia pese case ni edin in 10 terms so no, ye say ni say nkrofo human rights and ye breachy anyway a Supreme Court epene so no. A branch and some waka say yes, be our right. Now so I was saying na yet yes say. Sabi, and let me explain so you understand. You have the right to speech. Who are right say obekasa. So who are right say obekasa no interest say kona ko jina wo bi infiltrate na yedede. Obi wo obeka say I have the right to speech. Me wo right say me sum nyame. Na enu nti wo the speaker akwa akosi wo bi dan echi. You see, you have that right. But also what you say all right now wo no. It will end. Embra obi obi nso ne right eden ehya ase. It all right they can say na interest say kogina obi mpu na echi. Embra wada na kobo ni dede. Who disturb you on nso ne right. It is all right yeah human right yeah you say nkrofo ya. Ye tu omo afia konwa so yi. Ya violate omo human right no. Yes, but also mo hu ne say rights ankasa no the respect of other people and so rights ewo ho na die ntia na okasa obeka. I say in the case of Dr. Prince Obri Kran versus Attorney General, writ number J1/18/2021, dated 24 July 2024, Amadou JSC noted that the rights guaranteed under the Constitution are not absolute. Article 12(2) of the 1992 Constitution provides as follows: every person in Ghana, whatever his race, place of origin, political opinion, color, religion, creed, or gender, shall be entitled to the fundamental human rights and freedoms of the individual contained in the chapter, but subject to respect for the rights and freedoms of others and for public interest, just like what I said. Who are right there? Now, so I was say all right, no, irrespective will be full from so there. Example. Now, I'll say from the above provision, the rights guaranteed are subject to the respect for the rights of others, and secondly, the public interest. In his invaluable book and handbook of the constitutional law of Ghana and its history, Black Mass Publication 2021, Sir Kofi Kumado rightly posits at pages 217 and 218 that apart from clause 2 of article 12 of the 1992 Constitution, the limitations to individual rights must pass a triadic test, being that the limitations must be shown to be prescribed by law, reasonable and necessary in a free and democratic society. In the case of Samuel Okudzato Ablakwa versus the Attorney General 2013 to 2014, 1 SCGLR 16, Brobe JSC stated that public interest was defined in Article 295 to include any right or advantage which inures or is intended to ensure to the benefit generally of the whole of the people of Ghana. He added that public purpose was not so defined, but its ordinary meaning is not mind-boggling, giving a broad, wide, and liberal meaning to it. It may mean the aim or the reason for or behind a particular activity was definitely or intentionally for the public benefit or good. Even though the right to representation and the right to fair hearing are constitutional rights, these rights are subjected to the express limitations of the Constitution as well as the public interest. Article 56(1) provides that the right to form political parties is hereby guaranteed. Article 55(2) provides that every citizen of Ghana of voting age has the right to join a political party, and Article 55(3) emphasizes that a political party is free to participate in shaping the political will of the people. It is in the public interest that people are free to join political parties to shape their political rule. Therefore, where a person is submitted by the political party as a candidate for parliamentary election, it is deemed that the candidate expresses the political will and mandate of that political party. Also, where a person decides to contest as an independent candidate, it means he is presenting to the constituent his own mandate and political will. Therefore, a person voted for by the majority of the constituents has been chosen to represent the entire constituency. He speaks on behalf of the constituency and carries the mandate he presented to the people. This was affirmed in the case of Justice Abdullahi versus Attorney General 2022, GHASC 1, where the court held that each member of parliament is a representative of constituency and carries the right to vote and represent the interests of the constituency. Therefore, it was in the public interest that the constitution mandated under Article 97(1) of the the constitution, that a member of parliament shall vacate his seat in parliament if he resigns from office as a member of parliament by writing under his hand addressed to the speaker, if he leaves the party of which he was a member at the time of his election to parliament to join another party, or seeks to remain in parliament as independent member, or if he was elected a member of parliament as an independent candidate and joins a political party. Now, for this point, let me explain, because me hune se me readia eduechi mami tretrim aka akra na ye wi aka last page na ewie uti abrantie nsem a woka perfect point asem woka ne say yes senya me ma wote ase no obi a wo right, obi a wo freedom, nanso freedom of speech and interest kogina wo bi pun echi na ye dede o se wo hwe a obi a wo right se wo se wo to aba Ghana mrate se wo se obi a to aba, obi a wo right se wo se nipa ko ne to aba, right? Obi anso wo right wo se ogina ema ye to ne so den aba. Nti MPP for afenwoma kindi akwa kopiem wo court say sa enkrofu ya wo mo ye abambagbin decision na wo make ye no or violating enkrofu right, constitutional right, say ya to mo so aba no mo aba parliament na abambagbin na yi omu afiri ho and na Supreme Court agi atum say indeed the abambagbin ye na enye ba branch we dia wo tre say senior or right to freedom and interest say because you know be punu echi eye dede no over parliament no o ka say political party bi so na wo de ba and na menu so nti and na omo a wo mo sa constituency no ejina so de to aba ma wo na afi wa ba be pie wo political party no edin mu wo parliament ewie na afi wo san so ka say o ko a different political party so na wo expect say yenjina so na still tina parliament ho na wo de wo pese o trese wo right ne de e wo se wo right se wo se oda ne MP na so mo to abama wo no the reason why o mo to abama wo ne say eye political party bi so na wonam so a wo de ba he nti unso wa violate sangrofo ne right. What ya a branch no point I will make it, which for me I think it is very valid. At ya say all right ne dey yen respect and so right ne violate obi dey because enye nipa kro no ni decision so and asisi a wo pese odigina okwa ka nipa kro say o ma me we meye we o ma owie afi wo besesan that be you are violating that person's right ba call to abama o no o violate on so right ba wo dey wo di mirika ko say yen respect no to abama o say MPP edinti bra parliament and the waba parliament a wo pese wo di different political party and e kono na nipa kono yempene nga so o to abama for MPP nti ba ende wako MPP a wo pese sisi an wo pese o sisan o party no nipa kono still ono ne right nti o de to abama o say MPP nti no ono ne de yembongu na wo de o right a wo pese o da ne MP ne de no yenjina so party bi da enye ye ti uko obi punu echi na okoye dede a wo right say wo be kasa de nanso uni right say obey nipa kro ni dede, and that is exactly the same thing. Young guy we share reasons a woman or money example say bobo nsem so at ya say, and he went on and on and on and on and then gave the conclusion and everything, and I think say this is perfect. At ya said this is perfect for young guys to be saying all these things and to be writing all these things. No, it is good, it is good, very very young. I'm not sure he's even up to 30 years and what drop sa marvelous piece here what aba montre mo adwo comment box ni mo. Bedase.